every quarter. So thank you for coming today. For those that don't know us, we're Lavelle Law. Who are we? We are a full service law firm. Our main office is here in Schaumburg, and we also have an office downtown in Chicago. What do? We attorneys do a lot. There are a wide range of different practice areas. Of course, litigation. We have two of our litigators today that will come and talking today. But in addition to litigation, we also handle a wide range of other areas of law. Business formation, business transactions, M&A. We do have a very busy estate planning group who can also handle probate, trust administration. We have attorneys that can handle all sorts of real estate, commercial leasing, purchases, sales of real estate. So anything that you deal with, we probably have an attorney that can handle it. In addition, we always provide free consults to new clients in most of our practice areas. So if you're just looking for a second opinion, or you just want to sit down with an attorney, we'd be happy to sit down with you, provide free consultation. So please reach out to us today or whenever that comes up. A couple housekeeping matters. Restrooms are outside to the far right if you have to use that. In addition, we're not giving legal advice today. If you have a legal issue, we need to sit down with you, understand your facts and circumstances, because application of the law is always tied into what your particular circumstances are. So hopefully you find the information today rewarding. We have Jen T. and Matt Sheahin, two of our shareholders who practice in the area of litigation. And they're going to be talking today about some litigation strategies that you can use to protect some of your intellectual property rights, trade secrets. They're going to talk about some restrictive covenants, and then also some litigation strategies that you can use in order to enforce those agreements. So if you guys want to ask questions throughout your presentation, hold questions to end. Yeah, so if you have a question that occurs to you in the middle of the presentation, feel free to raise your hand. And I'm looking at opportunities at the end to answer any other questions you may have as well. So with that being said, I'm going to turn it over to Jen T.
Thank you so much, Ted. How's everyone doing today?
Good.
I'm so glad to see so many people in person. Post-COVID, we didn't see a lot of people in person, so it's nice to see everyone here. So today, we're going to kind of talk about some legal protections for your business. Specifically, I am going to talk a little bit about. There's us, Matt. Okay. So we're going to go through an introduction. I'm going to talk a little bit about non-competes. And then Matt is going to go into trade secrets, TROs and injunctive relief, contracts and managing risks. And then we're going to have a little Q&A session. So how do you equip yourself with the proper legal strategies for your business to be successful? Now, so many times we start a business and we're running and doing all these other different things and we miss major components. And then at some point, you have an issue and now you're in a lawsuit and now you're focused on that and you're not focused on your business anymore. So one of the ways, you have kind of safeguarding your assets, you have business owners, business managers, office managers, business brokers. All these people are going to want to safeguard their assets and safeguard their business. So one of the ways that you can do that is there is the ability to have an employee enter into an employment contract. And in connection with that employment contract, you might have some restrictive covenants is kind of the broader term for it. Underneath that term of restrictive covenants, that could be a non-solicitation. You can't solicit my customers for a whole year. You can't solicit my employees for a whole year after you leave. That's one type of restrictive covenant. Probably more popular, although the non-solicit is popular, is the non-compete. So what is it? It's a contractual provision that is put into an employment agreement that says that the employee cannot compete with your business in certain ways. It could be during their employment or after their employment, or both. Usually it is both. Now, because in our society, we have a capitalist society. We want competition. We want businesses to thrive. We want that. So we have kind of two competing situations there. We also want that business to feel safe in the fact that they just spent 10 years getting 100 clients, and they don't want someone to come in and essentially steal that from them. So because you're kind of looking at those two concepts, the court is trying to make sure that the non-compete is tailored properly to your particular business. So you want to make sure it is specifically relating to your activities, where you actually do business, so that geographic location, as well as time frame. How long is this going to go on? So the court's always looking at that because in general, a restrictive covenant like a non-compete is a restraint on trade, which we don't really believe in as a society. But in order to stop that theft and stealing, we do support it for a period of time. But the courts are definitely going to carefully scrutinize the agreements. Now, because of that, employers should have a lawyer actually draft their non-compete to make sure it fits all the requirements so that if you end up in a lawsuit later on, it's actually enforceable. So all that work isn't for naught, essentially. Non-compete agreements have been around since 1811. I was kind of surprised to hear that. 50 states have some form of a non-compete. Only 3 of them have a ban against non-competes, at least at this current time. So what is the court going to look at? The court's going to look at reasonableness. So the test in general is whether the covenant is reasonably necessary to protect the interest of the employer. So it can't be greater than the interest of the employer. It can't be unduly burdensome or create a hardship on the employee. And it can't be injurious to the public. So that's just a general concept. And in this reasonableness, you have kind of 3 components. One is, what's the activity? Is the activity directly related to your business? Or do you perform one specific type of work and that you're trying to stop that employee from doing other types of work that you don't even do? So you want to make sure it's specific. So its activity is the activity reasonable? Does it actually protect your business? The second is time. And the third is geographic location. So when you're thinking about the reasonableness of the covenant, those are the 3 things that you're looking at. So geographic scope. So the court will evaluate the connection between the geographic scope and the non-compete and the business interest being protected. So you might want to look there at, so let's say you're a small town doctor and you have other doctors that work with you and you do very specific type of work. Now, if that small town doctor opens up an office right next to you and does the exact same type of work, that's probably going to be protected under a non-compete. If that says you can't work in the whole state and the first doctor only performs work in that county, well, that's going to be outside of and not reasonable. It's not going to be considered reasonable by the court. The other one might be, I saw one, it was interesting. It was like a worldwide restriction, which immediately I was like, oh, this is great. We're going to be able to knock this out. But the problem was that it was such a specific industry that there was only 2 employers in the whole world about that. So that's going to be looked at a little bit differently too. So because it's case by case basis and there's general rules, you want to make sure it's tailored to your actual business. Another kind of example I gave here is has locations over the whole Chicagoland area. Then that 100-mile restriction might be reasonable. Temporal scope. So this is your time. 6 months, a year, 2 years. And this is also going to be looked at in the context of the activity that you're protecting. I like to say 1 or 2 years. I think when you get into longer years, you welcome the court into that to say that's too long. A 2-year restriction for a salesperson could be reasonable. A 5-year restriction on a doctor could be reasonable if it took them 10 years to get these clients. They're just kind of giving examples. Now, the court will evaluate the temporal scope of the non-compete in connection with your business interests, and they'll look at the length of time that employer took to obtain those customers. What kind of knowledge did the employee gain? And was their knowledge about that topic or about that customer, about that, was it only gleaned from being your employee? Would they have not discovered it otherwise? How much of a hardship is it to the employee? Can they not work? Are they not getting paid anything for an entire year and they can't work in the whole world? Well, that might be perceived as too much of a hardship for that person. They can't obtain employment. And then the effects on the public is just a general kind of concept. You can't have it be interest to the public. That's public policy. And then we have legitimate business interests. So what does that really mean? You know, again, looking at the totality of the facts and circumstances related to your particular business and your particular non-compete. So legitimate business interests that depend on the employee's exposure to the employer's customers and relationships and other employees. How permanent are those customer relationships? Did you have this customer for 10 years? This person only spoke with this customer during your employment, and then as soon as they left, they contacted that customer, and the customer went with them, and you had them for over 10 years. That's something the court's going to look at too. How much confidential information or inside information did that employee receive while they were employed at your company? And then the time, place, scope of the activity restrictions, which we kind of went over those three components. And the court can modify agreements. I mean, ideally, you want to go into court and the court to say, this looks great. You've made sure it's specific enough and you've limited it properly. You don't really want to get into, a year-long fight about whether or not this was properly tailored. Courts can modify them, or they could just strike them down. They've done that before. Okay, this term consideration, sometimes, people get confused about what this really means. Adequate consideration. Consideration is a term of art in the legal field, and it's not just, caring about somebody. It's getting something in exchange. So if I'm going to give you $100,000 and you're going to dismiss the lawsuit that you filed against me, and you're going to release every claim that you have against me, that's the consideration. It's the thing of value in exchange. So the same thing has to happen in the non-competes. Now, you could do, some people have done salary increases, some people have done bonuses. I like to connect it directly to the actual clause. If you want these clauses to be enforceable, say, I'm paying $5,000 for this clause, depending on the employee, or maybe it's $2,000. But separate it out. It's not part of your salary. Here's your salary here. Here's what I'm paying you for this. That's going to be, and I put it right in the employment agreement, right in the offer. A promotion, you want it to make sure it's an actual salary increase so that there's true consideration. So they're giving something for it. Now, this is this kind of came up or the employee worked there for 2 years after signing in. So in the context of an employee coming and working for you initially, they've never worked for you before. The consideration is the job itself. So you don't necessarily, sometimes it is good practice to just pay an extra sum or take $2,000 or $3,000 off salary and pay $3,000 for that actual restrictive covenant. But what happened in 2013 is a little bit of a funky case. And I remember reading it and thinking, oh my gosh, what is this really going to mean? Because this employee worked for a company who then that company was dissolving or becoming another company. And instead of letting the employee go, they offered him another position at the new company. But it was still essentially a similar, it wasn't any additional pay. And that contract the employment contract that they put before him had a restrictive covenant in it. They had the non-solicit, you can't solicit our employees, you can't compete with us, etc. Well, that employee only stayed with that company for 3 months. So he goes into court saying, well, I didn't get any information. I don't have any confidential information. I was barely there. They didn't give me anything extra. And the court ruled in his favor. They said, you did not provide that employee any consideration. He didn't get anything in exchange. Now, had that employee stayed there for 2 years, the court ruled that would have been adequate consideration because it was continual. You keep working there. So you got the job, the position over that 2-year period worked as adequate consideration. That case is called Premier versus Fifield, if you want to look at it. So how do you enforce a non-compete? There's a variety of ways. Matt's going to talk about a few different ways. But in general, I think the obvious one is it's a breach of contract. Here's the contract. Here's what it states. You breached it. Court, give me damages. Now, the person maybe took your customer list. That could be a breach of a trade secret. They contacted all your customers. That could be breach of a non-solicit. And then they worked for your competitor or started another company that's identical to yours in the same town. And you can get damages from that. Now, you got to show us, hey, we have a valid and enforceable contract. And my contract meets all the requirements of a non-compete in the scope of the activity, the geographic location. And now they breached it. The breach that occurred caused my damages, and now I want damages. And Matt actually tried a case not that long ago where, in addition to the damages that they sought against the employee, they sought damages against the employee's new employer, which Matt represented, like essentially seeking a disgorgement of profits. Well, you took my business and your company took in that money. I want the money back. So you as a third party employer, maybe not even knowing that this person had a non-compete, could get involved in a lawsuit like that. So this was also real interesting. Now, it's not as hot right now, but it's definitely going to come back. So the FTC attempted to ban non-competes. In April 2024, so just about a year ago, the FTC issued a rule. It was really long, like 75 pages. And they wanted to ban non-competes pre-existing, whether you paid your employee or not. So this, of course, caused an uproar. They said, you cannot have anyone sign a non-compete unless that employee is a senior executive involved in like policy and would be very involved in the business and makes at least 151,164. Why they chose that specific number, I don't know. And they said all bans. They said no before, after, all employees except for the senior executives who earn that much. And it would be even if it was entered into before September 4th, 2024. And this was the date that it was supposed to become effective. So it came out in April. It was supposed to be effective in September. In between lawsuit after lawsuit after lawsuit. You can see the kind of argument. Well, if you're a big executive at a company and your company paid you $50,000 to agree not to compete for a period of a year, you have special knowledge about that business. Now, the trade secret usually stays, just so you know. It's not like you could take the trade secret and give it to the new employee. But if you try to go and compete, so it was very interesting. Bunch of lawsuits. So right now we had first decision in the Eastern District of Pennsylvania. They upheld it. They said, okay, the FTC acted within its statutory authority. It's fine. It's an unfair method of competition. No non-competes. And the court denied what's called a motion for preliminary injunction to stay the effective ruling of the final rule. So essentially, the plaintiff, the employer probably, filed suit and said, enter an order stopping the FTC from actually enforcing this rule. This court said, I'm not going to do it. It's fine. Next court says, this one's in Florida, the Middle District. They entered a limited injunction prohibiting enforcement of FTC ban as to the non-compete. And they declined to stay enforcement of the FTC rule generally or to enter a nationwide injunction. So they just said, for Florida, we don't agree, or you cannot ban all these non-competes. And then one of the other cases, there's more than these two cases, but these are all still outstanding. The Northern District of Texas set aside FTC's ban, and they ordered that the rule could not be enforced. This resulted in the rule not being enforced all over the country at this point. There are multiple appeals going on, none of which have been decided. Where does this kind of leave us? It's unsettled. We don't know what's going to happen with this. There's multiple appeals that are all pending. At this time, you're not required to void or any existing non-competes, but that's not to say this isn't going to come out in some other way. Or maybe there's going to be, some part of it's going to be enforceable and then another part's not going to be. Or maybe you paid if there was a specific dollar amount. I'm just thinking of ways that they could potentially kind of compromise in between the two concepts of the total ban versus, oh, I paid this employer or employee for this non-compete. Why shouldn't it be enforceable? They got the money. It's like, what do you do then? Return the money? Unlikely, right? So that's kind of what's going on with the FTC. As of right now, there's no concerns until we figure out what's going on with these appeals. Just to know. And I think I'm going to be handing this over to Matt.
I got a question.
Yeah.
With the administration, do you feel it's going one way or just the other?
Heard anything from the new administration as to what they thought about the FTC ban? Have you?
No.
No.
Is there any difference between drafting and trying to kind of create a non-compete clause for contractors like 1099 employees versus the employees?
Yes. Yeah. And I think that 1099 employees, they're not really employees. They're independent contractors. And a part of being an independent contractor is that you have the ability to kind of do to direct your own activities. So, have you seen it in
I mean, you can, but it's very specific to your business and what you're giving them access to. Generally speaking, they'd be free to, go work for anything they want to. It's hard with because that relationship is much different. But you could insert a non-compete, like I've seen it where two parties are, somebody who's consulting company, that consultant goes and works there, and they have a non-solicit. Like, you can't hire my person direct and go to get my resource directly and cut me out. So that type of relationship, you can get a non-solicitation act. In fact, I'm working on one right now, and this one pretty clear that those are doing so.
Yeah, the NDAs.
Right.
Yeah. It's a little, sometimes people do that. They're selling their business. They're going to share financials and you don't want that other entity to disclose any of your financials. All of that is valid. A little different than a non-compete, but yes.
But they have proprietary information, free months, so on.
And it's always interesting to see, if that particular contract would stand up in court. It does have to be limited, like we talked about, kind of in the scope. And if it's a complete ban, you may be successful in court, but who really wants to go to court?
Sure.
Interesting.
Yeah. They don't want that out there.
Sure.
Absolutely.
First advise that outside of mandated route solicitations, trade secrets, and whatnot, that there was a salary minimum requirement from $60,000 or $70,000 in order for the American people to work here on vote online.
Which law was this?
It was related to others specifically, but I know the after requirements are just saying of one change from that.
Yeah, and I think that a lot of what the FCTC talked about was like Subways and Taco Bells and entities like that having their cashiers sign non-competes. So it's almost like you're coming in saying this is inappropriate. You're going beyond what you need. If this isn't protecting your adequate business interests. So I think what you're kind of talking about is companies going after and having people who aren't the main policy decision makers or people who don't make that much money either going to saying, oh, you can't work for a whole year. So you're having people coming to the Attorney General's office saying this is totally inappropriate. Why would I not be able to work as another cashier at a fast food restaurant? So I think that's kind of where the FTC was coming from. Hearing that from people like yourself or anybody throughout the country.
Well, that was the Attorney General for that one. But yeah, you were a salary requirement then the $60,000 or $70,000 rate of the
I haven't heard that.
Yeah,
Okay.
What if you have an employee, salesperson, that can be for small? Is she?
Well, I assume the non-compete covers all the work she was performing at the position. So
It doesn't specifically say all the what I just stated, but yes, and she would.
I don't think there's any rule against the fact that you brew it. In fact, that's requires more protection for you. You know, the employer is actually the one who's paying the employee to do this work. So I think it, depends on the activity, the scope, and all of that. But yeah, I think that would.
And you can put in her employment contract that anything she develops while she's with your company is on behalf of the company owns that. She well, she's supposed to share duty to you as an employer to work for your company. Salary, someone used to say that yes, fine. Yeah. What if their salary is below that? She needs more. Yeah, those are factors the court will probably look into. The specific bright line rule that they're talking about. Actually, I'd have to look into it
I want to
more.
look at it.
But it's a good question, and maybe John wants to us. Yeah. Yes, sir. But they did have it is they never looked at thing. Yeah, that would be some kind of partnership agreement or within your corporate, document, shareholder agreement, operating agreement. So that would be more Steve's team, a transactional team that would help deploy those types of agreements. But yeah, you can set up a relationship. Yes.
I'm curious about the like small business, real small. Because I'm 5 people. And while I have non-competes, I've actually enforced mine and got a 75% judgment in my favor. I mean, going after the person who coached my person and with 75, I feel like I have the right to go after them. Then like the is really where I want to go for it. It was
Resulting for sure. And I think that's why you do want to have an attorney's fees and costs provision in the employment agreement in the event of a breach that requires you to.
Yeah, but
you
against the third party, you don't have a contract with them. So generally speaking, you're going to pay its own fees, and that's the general rule, the English rule. It's only if it's in the contract and you have a contract with them, there's like your employee, you can enforce the attorney. Or if it's in the statute, pay Sam and he's losing a lot for his wages.
don't do it, Sam.
Yeah, he not only gets his back wages, but he gets his fees because it's in the Illinois Wage Payment and Collection Act. The only other way you're really going to get it is if they do something that's sanctionable, but the court finds it, it's kind of being on bail.
Generally speaking, like what would that cost look like?
What do you mean?
If I really having somebody breach these things, like I haven't taken any steps forward because I usually y'all scare me. Again,
I take that as a compliment.
I'm a mental health therapist. I'll scare you.
I'm sure you will.
But
But like, that seems to be the reason why, in my industry particularly, why people don't enforce them as well as take the necessary steps, even draft these things.
Yeah, what you're talking about is, really, I'm not exactly sure what they took. I'd have to talk to you in more detail about it. But there is a lot of times it's a cost benefit analysis and really what's the value of the damages that they kind of caused you compared to what the litigation can be. It's going to cost them too, obviously.
Right.
And just I always say, nationally speaking, in civil litigation, taking personal injury cases out of it, kind of more business cases, there's only 6 or 7% actually go all the way to trial. Most of them are disposed of by motion or someone abandons the suit or someone's defaulted. But at some point, most of them settle, the majority. Doesn't mean your case will settle. Just statistically, it's probable. But the best way to get a good settlement is to create a complaint, prosecute the suit like you're going to win at trial, and make them worry about it, right? That's reasonable. Analysis too, and hopefully solution. But if you got to try it, that's where it can get expensive, of course, and that's where you get it.
One case I had, it was a trader, and he wanted to go full tilt, and so we went full tilt, and within 14 days we had a full settlement. So it was, money up front, but it wasn't the whole case. We, came in hot and had an emergency hearing like the next day. So
Other cases I've had for you.
that's right.
So is it best practice, like if you have someone kind of maybe just starts right out of college, they sign their employer agreement or employee agreement, but then they've been there 10 or 15 years, like should they be signing a new kind of agreement as their job is changing? I don't think that happens, but
If you're going to sign
it's more valuable to the company.
let's say they've been 10 years and didn't have a non-compete and you want them to sign one, then you pay them, right? Here's a new non-compete, I'm going to pay you $1,000, $2,000, whatever it is, the considerations there. And, they sign it, then you should be all right. Really, you have to do it every time the job changes. But again, it might depend on what information they have access to. Maybe they're getting up to a position where before they didn't really visibility into certain processes, and then you probably would get it. What can you do as content? You have so what type of several contractors we have make up people. They're a free agent, independent contractor. It's going to be pretty tough to do. You have to check them using information that's sensitive that you own, which I'll get to. But you can't restrict them from working for somebody else if they're not your employee.
The reputation.
So, in the legal field, it's a certain things that you can do to restrict in your phone.
No, they're.
You have not anything at all.
In fact, I think it's an express lane. We can't.
The legislators carved out lawyers. Because a lot of them are lawyers.
Yeah. We have a shareholder agreement. We have fiduciary duty to one another. That means we can't take business opportunities, take employees, all that. So that would be a little bit different of a lawsuit. But yeah.
If you came to talk to Jen about a case and wanted to hire her, she'd have to do it through Lavelle Law. She couldn't do it.
Yeah. If I took that insurance on my own, I'd breach.
Same with our employees. They couldn't do that either. Those are more just general fiduciary duty laws as far as the employer-employee context, or us as shareholders together. We have to work for the benefit of one. Yep. with there's an Illinois trade secret law, which I'll get into. It's a good solicit and non-compete. That's not you want to put it in right for sure. While the employee is with you, they have to work for the company's benefit. They can't, unless if you don't have an employment contract, maybe they could because you don't have restricting. But anytime they're with you, for example, within my four walls, working for the benefit of the Lavelle Law, they've got to do that. I can't, if one of my attorneys wanted to be an Uber driver, right? What's that?
The whole, you get a trade secret and they stole a customer.
If they stole a client list, which I'll be into, that would be different. So, you can stop me anytime. Feel free to raise your hand if we're talking through this. What is a trade secret? Client list, right? So you might, and it's got to be a client list that's not publicly available or easily findable. Yes, so anybody can look through the Yellow Pages or Google, but it's got to be a client list that you've developed over the years, you protect within the office. Also, pricing models for a lot of manufacturing companies would be considered a trade secret if it's again proprietary. It gives them a competitive advantage. Proprietary formulas, of course, you think about all the coding. A lot of companies have digital coding that's valuable that they've developed over the years, or added labs with drugs, things like that. Those are proprietary formulas. Those are trade secrets that the company wants to protect, gives them an advantage. And there is not only can you put that within a contract, there is also the Illinois Trade Secret Act, which is a statute in Illinois. And to your point about attorney fees and something like that, I think the Act actually, if you prove the violation, the Act there does provide an avenue to recover attorney fees. So even if you didn't have a contract, if you had a claim under the Act, you may be able to get fees. But the information must be sufficient. So there's some pretty legalese here, so I'm not going to get too deep into this, but it's got to be sufficiently secret to derive economic value. The subject of the efforts are reasonable under circumstances to maintain its secrecy. So, in case I'll give you an example of there's a lawn irrigation company dispute. A seller sold a business to another person in the industry. That company just fired everyone, and then was mad when a lot of the customers went to the company. Well, number one, I thought this doesn't have anything to do with this trade secret, but I thought he handled that transaction very poorly. He had no transaction team. The people that are hiring lawn irrigation systems are usually the same kind of guy coming to their door, and all of a sudden they don't know that he sold the business, and there's some new person there saying that this is their new technician. Just a very bad way of doing it. But he tried to sue my client, who took that person that was fired on. And not surprisingly, a lot of the customers followed that technician. That's who they worked with for years. He didn't have a non-compete. That guy fired him. And he sued for theft of the client list. Okay. And the evidence was debatable about whether he actually stole it or used it. There's arguments on both sides. But the court really focused on the fact that they didn't keep it secret enough. This client was out in the office for anyone to see, for the technicians that work out on the field, for the salespeople, for the executives. It was in a book sitting out there for everyone to see. Now, if they had the client list like ours, there's certain things in our systems that only shareholders can see, right? You got to have a password to access certain things. Now, my associates and people like Sam can access a lot of our files, but certain sensitive information, financial information, proprietary information about how we handle certain things, those have got to be protected, password protected, digitally protected. Only a certain sect of people in the company should have access to it. You've got to show that you really try to keep this secret. Okay. Now that was done, and that employee, for example, stole someone's password to steal the client list, and then you've got an email, him emailing it somebody shouldn't have had access to his Yahoo email account. Now you've got a smoking gun, and you're going to be able to allege a good claim against a violation of the Trade Secret Act.
Question about you blocked it for data not competing. It's questionable as to whether it's enforceable based on the law. Yes, you for the services you can provide to the county. This paper that says that that person solicited you, and if you give them solicit them to complete set work. Does that
Sure. I mean, customers and clients are free to go wherever they want, right? I mean, they don't have to stay with company A.
well, there's an non-compete. The company that had that is going to say, well, you just told them to sign that. Oh, I don't know about that.
Yeah, that's going
And
to be.
we have a specific case right now that I want to refer because of that. They did make a mistake.
Yeah.
Different.
That is a big back question because, case clients is going to say, hey, they came to me. I didn't go seek them out. I didn't solicit them. They found me. I said, and frequently when attorneys move, you'll get the letter that says, hey, I left Lavelle Law and went over to ABC Law.
Right.
Here I am. And that is not necessarily a solicitation, just saying I moved. Now, if a client wants to go over because you're that client's guy, then there's no violation of a non-solicited because you're not soliciting. They're coming over. But that, of course, the former employer is never going to believe that. They're going to say you're just lying because you want to this client. Those are enforced. It's a lot. And any company that has a client is going to try to protect them. If the client wants to move, they're free to move. They're not, the ability to keep a client forever. They're not bound to. Sorry.
One of the things that always comes up, especially with websites today, is
Yeah.
Why? So that
True. And that'll be, again, if it's publicly available and you put it out there, you're going to have a hard time arguing that it's, again, secret. Exactly. Right. You mean just like saying what's outside the business, it's known by employees, what kind of group within your company, the secrecy again, words, limited access. If you have these, they're kept in a locked drawer, some manager or thing to be able to see how much money you spend. I mean, the court will look at that. If you spend, $1 million developing these clients, and this client's been with you for 10 years, that's going to be much more easy to convince a court that I had a near permanent relationship and I expected to have this client next year, as opposed to a client you just got 1 year. You may not have developed this expectancy to keep them. And then the ease of which the information is duplicated, again, to your example, it's on the website, reverse engineer it. So the element, you got to prove that the trade secret existed, that it was misappropriated through improper acquisition, and that the owner was damaged. So, for example, on an IDP, to this, we had a case where it was like a market employee. There were probably 10 of these marketers in this room within chief mental facilities. So, get results. So this person had worked there for one of the 10 companies for 5 years. They had an opportunity to quit, and they went to work literally to like the next cubicle over to a competitor. So that one was fairly easy, in my opinion. I put it the TRO, chocolate too, everyone show that to it. It's damaging us because we're taking clients that we should have gotten. And we had developed those relationships. We had introduced this market to all these companies and people that we had a relationship. So that the court agreed with us. That's the violation. So that NDA is always a good idea if you're getting into anything proprietary that's secret. Some examples, or where you're working with the company and they want you to sign an NDA. That's the reason they want to protect it. Again, internal security policies. You really want to get IT team to protect the information. That's really convincing in court to show all the steps we've done to take care of this information. I had one case where the guy literally stole the information from the computer. They had an email from them to his suit. He tossed his laptop into the spoilation of evidence, and that's pretty easy proof because you just tell it, this guy admitted to throwing the laptop in the bin. He obviously admitted it. So you want to also train your employees about how to keep this information secret, obviously, especially the ones that have access to sensitive information that they're not supposed to share. You want to monitor it. You want your IT people to check on this stuff. Has anyone been downloading stuff? Has anyone been emailing proprietary information from their work email to a personal email? You should have mechanisms within your company if it's sufficiently secret to protect and look at that stuff. And then we'll talk about some legal remedies. Talk about the Illinois Trade Secret Act. That's separate from the contractual obligation you could create within a contract with your employees or contractors. You want to document what the trade secrets are, protect you. And again, in this age, you really want to leverage your technology to protect it. So, when someone steals your trade secret, well, generally speaking, you want to get to that. You want to bring that to a stop as quickly as possible, right? And the longer you let it go on, the more damage you're going to be caused. So there are emergency procedures within the court system to address that. One is what we call a TRO, a restraining order. You may have heard that in like a criminal context where someone's, stopping certain. But in a civil context, it is literally stopping somebody. So, for example, in the example I gave with the market court order, she couldn't go to work anymore. She had to stop for it. She couldn't go back to that location. She was precluded from doing that. Another case where one of the shareholders was selling the company's stuff out the back door. And we had computer keystroke programs that we could show that what he was doing, selling it out from under the company. We had video, and the court stopped him. They literally, we removed him from all the access to the corporate records, bank access. He was basically kicked out of the company. He couldn't take his shares at that point, but he was fired and completely cut off from all access. So that was done through a TRO and a preliminary injunction. So it's useful in those type of breaches where you want steps. So the TRO, by its very nature, under the rule, is 10 days. It can be extended either by agreement of the parties. A lot of times when you win this motion for TRO, you kind of got, you're not done with the case. It's at the beginning. It's literally, I file a complaint and I file this motion right at the beginning of the case. And I can get a hearing literally the next day. I've served someone on a Thursday night at 5 o'clock on this driveway and had a hearing. So, with affidavits, a verified complaint that my this leaves attesting to that it's true. You have to file it. Once that TRO is in place, if you win it, now that person is restricted from doing whatever you're asking the court to restrict from doing. He does have rights, though. He can bring, he can force you to an evidentiary hearing, which is called a preliminary injunction hearing. And that is a very kind of just in regards to what we call equitable relief. We're not talking about money damages here. We're talking about the court preventing someone from doing something, which is equitable. So if you have a TRO and the losing party thinks it was issued improperly, they can ask the court for a preliminary injunction hearing and actually put on live witnesses to try and change court's mind. Usually when you win the TRO and you have a really good case, you usually talk to defense counsel like, you really want to go through this because I'm going to go to injunction level 2. Front to go try this part of the case, and it's not even going to be totally over. But we've had preliminary injunction hearings within the court system. I had one case where they filed out for an injunctive relief and never brought it to motion. So I thought their claim was weak. So I noticed up their motion, their preliminary injunction motion beat them in court. And as an opponent, I can do that with the rules. So, and then we had no injunction. So my client was free to do what he wants while the rest of the case proceeded. Went on for a couple of years. Wanted to try. Those are very useful emergency type of procedures that the court will employ in these type of situations. It's really trying to prevent imminent harm. You know, if someone stole your client list, clients are leaving. You know, you 10 left one day, and now you got next day another 5 leave. You can't let that go on. Yes, you're going to be able to probably at some point prove that you were damaged monetarily, but your whole business is at risk if you don't stop now. And that's why you get this emergency relief coin. Again, you can stop former employees if you have the right contract in place from poaching your clients. And you got to act quickly. Don't sit back on this stuff. Really get to an attorney as soon as possible, because every day is a matter. And the court will look at that. If you sat on your hands for 3 months and then you bring them a TRO, they're going to be like, doesn't seem like an emergency. You didn't do anything for 3 months. You know, you really want to act quickly. And you got to have the evidence ready. It's very important to the attorney about what information would with that TRO. So this is kind of more legalese. I will go through it a little bit. You have to have this. These are the motions that we have to file with the verified complaint to get the relief. You have to prove these 5 elements. You got to have that clearly ascertainable right. That's usually your contract or a violation under the Trade Secret Act. You have to say irreparable harm will occur without the injunction to court. You don't stop this. My companies continue to suffer damages on a daily basis. That's why it's irreparable. Yes, we could probably prove somewhat how much money towards the end, but it's happening every day. It's a continuing monetary harm, and we got to stop it now. The court will do that. There is no adequate remedy at law, meaning remedy at law means money, right? So if money damages aren't going to compensate, because if you allow this continuing harm to go on, I might not have a company. That's an argument that will work in court. The court will try to stop that. Or if you have like the proverbial, sexual catch on an airplane runway, yes, it's about money, but if you don't stop them now, we're never going to see the money. So that's another defendants. When I'm on the defense side, I always try to argue that we do have remedy at law. And so that's one of the big arguments that will happen in court. You got to prove likelihood of success on the merits. You don't have to prove that you're going to win because it's at the very beginning of the case. But you got to convince the judge that I have enough evidence here, not just a complaint, but I have enough evidence. I have a verified complaint. I have, exhibits here that showing that he stole information, or an email that he emailed the information out, or evidence from witnesses that saw that person, that marketer who was working for me, now is working, 2 cubicles down. Something that the court can take into account before a full hearing with live witnesses that you have. Then there's a balance of shifts, again, public interest that they'll look at. They don't want to hurt the public. But a lot of times that happens with like doctors. Some doctors try to prevent one case where they tried to prevent this doctor from working with 30 months. And he had moved about Hispanic interest that really didn't have one. And the court agreed with me that this is really hurting the public at large here if you don't shrink this 30 miles because this community will suffer without this doctor. And that way I got the court to shrink the geographic limitation from 30 miles to 5 miles. And I got the state practice where he wanted to. The burden of proof, if you file a motion with TRO and preliminary injunction, you have the burden just like any plaintiff. You got to carry the burden. It's a higher burden than typical civil trial, which, criminal trial, is, beyond a reasonable doubt, not 100% sure that he's guilty, but 95%. We don't talk in percentages. No court or judge will ever talk like that. We say more probably true than not true in a civil case. You just got to tip the scales of justice in your favor. If you do think of percentages, you just got to get a little over 50% to win the case. In a TRO, you got to really lay out the evidence in a higher burden, what we call clear and to work with that to you. It is an emergency remedy. It is that the typically rushes to issue. It's difficult to get. So, and rightfully so, it should be. But as long as you have all the evidence and you satisfy all the elements of the cause of action, you should be able to obtain that relief. As far as our office, I can't tell you how many people, and to your point, ma'am, about how litigation is so expensive, that's for sure. You talk to Steve and my chair about getting your contracts in the best shape possible. That's really your best protection. You'd much rather spend $2, $3, $4, $5 grand with our team there to put in really good, solid contracts, to put in those attorney fee provisions, put in those venue provisions, jurisdiction provisions, to put in rock solid non-explicits and trade secret information, protection of proprietary information. That will hopefully give you the benefit. And a lot of people, litigation is last resort. Sometimes you in those TR situations, you have to go there. But if there's an opportunity to send a demand letter and maybe resolve it short of court, a solid agreement is going to help you do that. Indemnification and limitation of liability clauses are very important. This isn't necessarily as much about trade secret as it's about protecting your business. We had a case with a trucking group. They hired for a load, got into an accident in Nebraska and killed a kid. And the trucking group is being sued. It's ridiculous, but she has an indemnification clause that says, hey, you, the trucking company, have to indemnify me for any accidents that happen on the road. So even though she's been sued, that trucking company is actually going to pay for her defense and come out of pocket to say, pay me. So she's paying me now, but we're going to get paid eventually by the truck. Those are enforceable and very good to have in certain situations. You can also put in dispute resolution clauses. Again, litigation is the last resort. Jen and I love to do it. But it's not our money, it's your money, right? And you don't want to spend it unless you absolutely have to. So you can actually put in for different types of disputes, both with employees or with contractors, that before you go to litigation, you can contractually require them to, even before you go to any of these other things, to like maybe go up to the CEO levels of the two companies and have a meeting and over a period of 30 days, 45 days, try to work something out before all parties go to litigation. Or a lot of times we'll set it up where the CEO or CFO level will have a 30 days to work something out. If that doesn't work, then we'll go to mediation or arbitration. Those are processes outside the court system that are, arbitration is essentially an outside the court litigation, but instead of judges, you have an arbitrator, and it's private. It's not public, so nobody can see exactly what's happening because it's in private form, and it's usually a little faster. I don't necessarily like it because it doesn't have the same type of protections that an open court system has, and I don't like it if I'm going against, like a credit card company or someone there that has a million arbitrations, because I feel like their lawyer and the arbitrator are like going out to lunch every day and I'm not getting a fair shake. But in an arm's length transaction, an arbitration clause might save you some money. Or a mediation, you force people to go to a mediation, which is an out-of-court type of settlement process where the parties submit position papers to usually a retired judge There's a couple companies in the city. Chams is one, ADR is another. When these judges retire, they get like 97% of their last year's salary. And then they embark on this second career as a mediator. And the good thing is they've tried all these cases. They've seen these disputes before. They've seen this movie and they know how it ends. And they're very good. Well, good ones are very good at resolving cases. And sometimes they come up with creative ideas that maybe the parties aren't thinking about to resolve cases. And we've settled a lot of really big dispute cases with a mediator. You do have to pay the mediator. I actually think that's good because both parties have some skin in the game and they want a result that kind of motivates the parties. And then managing risks. You want periodic contract audits. If you hadn't had your contracts looked at in 5 or 6 years, and it's a contract that you're using again and again and again, and it's putting a lot of your business risk into that contract, you might want to have our team at least take a look and see if there's anything we think we might be able to add. We always say you should have attorney drafted agreements. I know there's a lot of AI, chat GPT, get a lot of stuff online. But if you get an attorney that sits down with you and talks about your business, you're going to get a much better agreement. It's tailored to your needs, specific to you. This is unique. That's why we got to talk to each client, their situation, try to get the best solution for them. So schedule a free consultation with Lavelle Law anytime, and we'll assess your situation and help you out. Are there any other questions?
I have Tommy.
Sure.
Travel advisor and consultant. We go back terms and conditions. We're small. But one of the way I reduce risk is getting them travel protection that they have to sign away from me. But you made a good point to review my contract, my terms and conditions 5 years old.
Yeah.
So
Yeah, and I can tell you, again, back to your point, I've had so many clients have to sue someone or get sued. Mostly they have to sue someone, maybe for money that they didn't get paid. And if it's, 25 grand, it's worthwhile going. Certainly like 25 grand, so it's really not. Way, if you have a contract with that person, to get that attorney fee shifting provision within the contract itself. That is enforceable. It gives you a lot more leverage. Because the other person, if you don't have that there, they know you're going to be reluctant to sue because you're going to be out of pocket however much the attorney. So will they, but you're not going to be able to add the attorney fees on top of it. For claims where you have the fees, I've seen cases where people got awarded 100 grand in fees, $50,000 claim. The fee shifting provision gives you a lot more leverage and it gives you more freedom. You do have to pay the attorney along the way, but at the end, if you win, you can petition the court for the fee, and it will get awarded too. The court will go through an exercise as to whether it's reasonable and necessary if they really want to fight it. Most the large share of fees. And that's huge. It's huge in negotiation too before you go sue. But if you don't want to pay me now, that's fine. I'll sue you. But I'm going to get my fees too because it's an account. That gives people pause to call your bluff. Not everybody. You're always going to have unreasonable people on the other side in a lot of different situations. And that's usually when you end up with litigation, unfortunately. Any other questions? Well, everyone for coming today. I appreciate it. A lot of good questions today. And one that we're going to look into, and I'm going to try and follow along. We'll put up an article on our website in the next month or so about that bright line rule.
It's under the online freedom to work. So 75, and then on 2027, it goes 80, and it's like incremental.
So that isn't specific on us.